Welcome to Renters' Rights Radio.
Welcome back to Renters' Rights Radio with attorney Debi Rumph, founder of Law Offices of Debi Rumph. Debi works with Florida renters every day, including families living in mobile home communities where the rules and pressures can look very different from a standard rental. I'm Evan Mack, and today we're breaking down how mobile home lot rent really works and why misunderstandings about it could create serious legal risks. Debi, my dear, welcome back.
Thank you so much, Eben.
So Ms. Debi, what legally makes a mobile home, lot rental different from a standard residential lease in Florida?
They are night and day, Evan. As we know, a standard lease, it includes the land and the building. So normally a tenant would come in, they meet a landlord, they're going to rent the land and the building from the landlord. However, a mobile home lot rent lease is very different. The only thing that the tenant is renting in a mobile home lot lease is just the land.
So in many of these communities, the tenant owns the mobile home itself, but the rents the land underneath it, like you said. But how does that ownership split, affect the balance of power between the tenant and the park management?
It affects the balance of power tremendously. Now, as I indicated, the only thing that the mobile home tenant in a lot lease is leasing the land. The tenant in that situation is bringing their own building to the lot. Okay, so that gives the landlord a lot of leverage, no pun intended. If there is a dispute between the landlord and the tenant, and there needs to be a termination of the lease, or if there is an eviction, the tenant must remove the building from the land. And if the tenant does not remove the building from the land, the tenant can be seen to have abandoned the building. This is huge and crucial, Evan. Why? Because if the tenant owns the mobile home, the building, they're losing all of their equity in that home. Or worse yet, if they still owe money on that mobile home, they're still going to have an obligation to pay for that mobile home, even though they've been removed from the land.
Wow. So
So it gives the landlord a lot of leverage in these relationships.
yeah, it seems like it. So the cost of moving a mobile home can be significant and sometimes unrealistic for certain people. How does that, that economic reality impact a tenant's negotiation power when, disputes arise?
Honestly, Evan, it takes so much leverage away from a tenant. If you could imagine a tenant in a negotiation posture, at the end of that negotiation, the landlord knows if the worst happened, if the tenant wants to save their building, the actual mobile home, the tenant's going to have to come up with $20,000 to remove that mobile home, or risk losing it. So as you could imagine, landlords have a lot of leverage. No one wants to be at the end of a dispute and lose their home or not be able to come up with the $20,000 to $30,000 to move the home. So it creates a lot of leverage in the landlord and very little in the tenant.
Mm. So let's narrow it down a bit on the lot rent specifically. What authority does park management actually have to increase the lot rent, and where do those tenants commonly misunderstand that authority?
So as you can imagine, I just described a scenario where I described the landlord has all of this leverage and the tenant has very little. Fortunately, the state of Florida has come in to try to protect the tenants in this very unbalanced relationship. So, what Florida law says is that a landlord cannot go up on the lot rent without justifying the increase based on market conditions. So once a tenant agrees to a lot rent, and they should have that agreement in their prospectus or in their lease, the landlord should not be able to just increase the rent just because they feel like it. If you could imagine, if the landlord knows you have to pay $20,000 to $30,000 to move, the landlord could just increase your rent as much as they want because good luck moving, right? So Florida law says the tenant has a right to require the landlord to justify the rent increase. And if there's a dispute as to that rent increase, then the state of Florida will step in to try to help mediate it. So where a lot of tenants are confused is they're very confused on this process. So they'll say, "Hey, I don't agree. My perspective says this, and I'm only going to pay this amount." But if they fail to go through that process, the landlord's just going to serve them with a 3-day notice, file the eviction, and the eviction 99.9% goes through because they don't have the necessary um, know-how to alert the court that there's an actual dispute on the record and that they followed the dispute procedures that's in Chapter 723.
So, okay. So, Miss Debbie, so when a tenant receives a rent increase that feels aggressive or sudden, kind of what you were talking about, what legal risks should they evaluate before responding?
Evan, these are loaded questions. It's tough. It's tough because many of these tenants don't recognize the imbalance of power that they're actually in. So the things that I invite tenants to evaluate before they move forward is number one is who else is complaining about this rent increase? Do you have a mobile home owners association that could step out and take over the dispute? Is there a tenant association? You do not want to step out here alone. So I always ask tenants in these situations, who else and can this be done collectively so that there's more protection for the tenants? And then the tenant should make sure that they fully understand the procedures under Chapter 723.
If a tenant believes the increase may not comply with Florida law, what early procedural steps matter most? How can mistakes at this stage weaken their position?
Mistakes at any stage is going to weaken their position. As you can imagine, the mobile park landlords have attorneys, and they have attorneys who have structured their strategies, these documents. They're already lawyered up. They're already 10 steps ahead of the tenants. So, what was your question again, Evan?
I said, oh, if a tenant believes that the increase may not comply with Florida law, what procedural steps matter most? How can mistakes at that stage weaken their position?
Again, mistakes at any stage are going to weaken their position. The landlord is already lawyered up. They've had lawyers draft documents. They consulted with their lawyers before they decided to issue the rent increase. So they are already 10 steps ahead of the tenant. The thing that is most important, as soon as the tenants receive the notice to increase the rent, is to request a meeting with the landlord to go over that rent increase. The tenant should make sure that the landlord has to sign for this notice. In fact, I would highly recommend that tenants send it overnight mail, required signature, certified mail, required signature, and an email asking for a confirmation that the email was received. But that's the most important thing that they should do as they regroup, come together, and plan to attack the rent increase as a collective whole.
But Debbie, what about this? What types of documentation become critical if this dispute escalates?
So the notice of the rent increase becomes critical. What other mobile home park landlords are charging for similar lots become critical. Proof that you served the landlord with the request for the meeting is critical. Also, following up with the landlord. A very common tactic is the landlord's just not going to respond. You want to show that you followed up at least twice for the meeting and ask that the meeting be scheduled, you want to document that. And if the landlord refuses to set that meeting, you definitely want to report it to the state of Florida, and you want to consider whether or not you need to file a lawsuit against the landlord for a wrongful attempt to increase the rent.
In the context of a lot rent dispute, when does management behavior cross the line from lawful enforcement into unlawful retaliation?
Again, very loaded question, very difficult, because I'm going to tell you 99.9% of the time the landlord is going to retaliate. However, here's the big problem. It's not retaliation if it's true. For example, if you complain about a rent increase, you can almost expect the landlord's going to start complaining about your behavior. Now your lawn isn't cut enough. You're letting the dogs out and they're not on the leash. They'll be there taking pictures and documenting ways to be able to send you a 7-day notice. They'll attempt to trick you into not paying your rent timely. They may reject your rent. They may return your check on your doorstep. They'll do a number of things to try to trip the tenant up. But the problem is, if it is true, it's not retaliation. So if the yard is unkempt, it's not retaliation. If you're letting the dog out, not on the leash, the law says it's not retaliation. So that is the biggest thing that tenants need to understand. It will feel like retaliation, but the law will not deem it retaliation if it's true.
Why is it so hard to prove, if you feel it is unlawful retaliation? Why is that so hard to prove for a tenant?
Because retaliation is a state of mind, right? It's if the landlord, obviously, if the landlord came to you or wrote you an email, "Dear tenant, I am going to cite you for all of these things because you complained about the rent increase." That's a clear case of retaliation. You are able to prove that the landlord intended to retaliate against you because you complained about the rent increase. However, very few landlords do that. Instead, they just start documenting things that are true that they could now go against you on. They could prove the lawn looks a little messy. You're storing things in your backyard that you're not allowed to store. So if it's true, it's you not proving that they're doing it because you complain. They're going to prove they did it because it was true. So you have to prove what's in somebody's intent, what's in their mind, and that's very difficult to do unless they gave it to you on the silver platter.
Hmm. Many tenants fear losing both their home and their lot. What is the legal distinction between eviction from the lot and forced removal of the mobile home itself?
So there are huge physical differences. As I indicated, if you have a mobile home lot lease, the landlord's going to remove you from the lot. The problem is if you don't move your mobile home, you're also going to be removed from your mobile home. So the legal distinctions are big, but the practical distinctions are very small. The result is you're going to be removed from both because now your mobile home building is trespassing on that lot and they're going to remove you from your mobile home. So you're effectively removed from your building that you've paid for or are paying for and the landlord's lot.
Mm. So, without sharing specifics, can you walk us through a situation where a tenant, initially felt stuck in a lot rent dispute and how strategy, documentation, or timing changed the outcome for them?
Absolutely. I represented a mobile home owners association, and we very quickly, upon receiving the lot rent increase, requested a meeting. And the landlord ignored us. We followed up and they ignored us and they started increasing people's rent. We complained to the Florida Department Business and Professional Regulation. It did take us some time, but we came back victorious. The rent increases were struck down, and the tenants did not have to pay the increased rent.
Amazing. Miss Debbie, thank you for your time.
Thank you, Evan.
All right. That wraps up today's episode of Renters' Rights Radio with attorney Debi Rumph. If you live in a mobile home community and you're dealing with rent issues, pressure for management, or unclear rules, you're not alone. Visit DebiRumph.com to explore Debi's unbundled legal service and learn how to protect your rights with confidence. Thanks for listening, and be sure to like, leave a review, and share this episode with someone who might need it. Thank you so much, and we'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.